for those of us that practice in Virginia, also excited that we're going to have some CLE credit that we're going to get from this, which is great too. So if you haven't requested that from Mary, please do so. She'll send you the paperwork with the code to get your 2.5 hours in Virginia. I'm really excited to hear Rick talk, and I'm going to shut up in a couple of seconds so that he can get started. But you know, I just in trying to learn a little bit about him and reading his bio, the first thing that jumps out at you is he says, "I represent regular people," and I just love that. I just love that so much because of the way the insurance industry tries to float terms like liars, fakers, and frauds to sort of paint our clients. And I just love the fact that Rick brings it back to that. And I'm really excited to hear him talk about his new book from 2020, The Way of the Trial Lawyer, and some practical and technical stuff he's going to talk to us about to help cure some defense misconduct and those types of things. And like someone said at the beginning, I think it might have been Rick when he was working on his technical issues, there'll be some Q&A at the end. So don't feel like you have to, you know, cram the chat with all that stuff. We'll have an opportunity to take questions at the end. And with that, I'm going to turn it over to Rick and give him a warm welcome, and excited to hear you talk, Rick. So thank you for being with us.
Thanks, David. What I thought we would do today, I discussed this a little bit with Mary yesterday. I thought what we would do is go through a couple, what I think of as nuts and bolts techniques that surprisingly most trial lawyers don't know much about, which is curative instructions and offers of proof. My hope is that as we go through those, you'll be thinking about questions. When I finish the curative instruction part, we'll ask if there are any questions. When I finish the offer of proof part, we'll ask if there's any questions. And then I'll move into you know, what I consider higher level stuff having to do with, I don't know what to call it exactly. Maybe we'll call it your secret weapon at trial, and then your secret Achilles heel at trial. That's and then we'll do question and answer on that. You know, I'm always of two minds about the size of the audience at a CLE. When it's a big audience, that's of course good for my ego, which I always like. But if it's a small audience like this one, we have a chance to kind of address the things you're specifically interested in. So I'm really going to try to encourage you. I don't have 3 hours of material. If you don't ask questions, we're going to be done early, and you Virginia people may lose some of your CLE credits. So part of the responsibility is on you to ask questions. And what Mary and I are going to try to do is take questions in two ways. They will not be answered if they're in the chat. But if you have a question, put it in the Q&A section, and we will turn to that at some point. But also, sometimes, even on these, in this format, we're able to actually get you on audio. And so Mary and I were not sure we're going to be able to do that, but that's the plan after the curative instruction and offers of proof section, and we move into the next sections. When it's time for questions there, we're going to experiment and see if we can't get actual audio going and see how that goes. And, you know, when you ask your questions, really it's to raise issues that are of interest to lots of people. And it's funny, you know, in the question answer part, in my experience, some of you have probably seen this in CLEs, it's because we're lawyers, we tend to like unload on the facts. You know, I've got a 52-year-old person with a bad back. He worked for 15 years as a manager at Walmart, and we go all into the facts before we even get to the issue that we want to discuss. Well, that's not very helpful. So what we want to do is look at the issue, sort of the bottom line issue that's bothering you. They're calling my client a liar and a cheat, and I don't know what to do, that kind of thing. And then I can ask you for more facts if we need them. So Yeah, one of the most common questions back when we did in-person CLEs, one of the most common questions I would get would be some variation of bad defense conduct. The defense is violating the motion in limine that we got from the judge. The defense is clearly bringing up issues that are not relevant. I'm sorry, not relevant, but clearly prohibited by our state law, like in Washington here, for example. You can't even say the word insurance without the ceiling falling in. So anyway, those are the most common questions. And you know, what I found myself doing is saying some of the same stuff over and over again. So I thought what we would do today is talk about what do you do if the defense violates a motion in limine. And let me just, we're going to be a little rough here at first as I figure out how to do this. Okay, so let's say the defense has violated a motion in limine or other court ruling or other obvious principle of law. And before I go further, Mary, can I ask you, does everybody have the handout that we gave?
Yes, I sent it out to everyone along with the Zoom link. So if they're on here now, they also have access.
Okay.
And remember, if you wanted to do your presentation mode, it's F5.
Yes, I did
Okay.
remember. Thank you.
Okay.
And
All
I got to
right.
share the screen first too, right?
No, you already shared your screen.
Oh, I did. All
Yeah,
right.
we're
There
looking
you
at
go.
your screen.
Oh, all right. So let's go to F5 then. All right, here we are. Thank you. So you can follow along. You can on your hard copy if you want, on your screen, doesn't really matter. The point here to just get right to it. All right, so the defense, let's take a hypothetical example. The defense has given an opening statement and just run right past your MIL order from the judge. I mean, you'd be surprised how often that happens, not just to you, but to other people. The very first thing you want to do is move for a mistrial. And I know the bubble over most of your heads is, I fought like crazy to get to trial, to get my trial date, to get into court. I spent all this money on experts and so on. I do not want to move for a mistrial. You don't have to worry. It will never, ever be granted. I've done this, I can't even imagine how many times. The only time a mistrial was granted was about the 5th time I moved for a mistrial in a trial. And at that point, the judge had about had it. The judge is not going to grant the mistrial. What you are doing when you move for a mistrial is you are telling the judge, this is really important. This is serious. This is not just a plaintiff lawyer whining about unfairness and how hard the world is. This lawyer thinks this is a very serious problem. And they do. You make a motion for mistrial, the judge will sit up and take notice. Next, as you move for your mistrial, it's really important to frame the issue properly. You need to explain to the judge, first off, what the prior ruling or the rule of law was. And sometimes they forget, or in some jurisdictions, another judge has made the motion in limine rulings, and now the trial judge is presiding. I mean, there are all different reasons why you need to explain to the judge what the prior ruling was. Then you need to explain what happened and why the prior ruling or rule of law was violated. And that's not always as easy as it sounds, because the judge and you, and maybe even the defense lawyer, were focused probably on a particular issue at the time. For example, I don't want any reference to insurance in the trial. So I make a motion, there shall be no reference to insurance in the trial. The judge grants the motion. And in opening statement, the lawyer says, you know, Mr. Plaintiff has other sources of money or has other sources of compensation for his broken leg. You know, he doesn't say the word insurance, but clearly implying that there's insurance. So you've got to explain to the judge why what just happened violates the law. And, you know, likely, given the hypothetical I just gave you, the judge is going to find a way to try to excuse the defense lawyer. Judge is going to try to say, well, you got close to the line, you didn't go over it, but I don't want you even close to the line again. Judge does not want a mistrial, but also wants to start reining in the judge or reining in the defense lawyer. So what just happened and why the prior ruling or rule of law was violated. And then if you can work it out without seeming obvious, you want to start positioning this as it's not you versus the defense lawyer, it's the defense lawyer versus the judge. This is an attack on the judge's authority. You couldn't have been more clear, Your Honor, when you said no reference to insurance, and that's exactly what this was. The defense attorney tried to do it indirectly in a sneaky way, but it would be understood by the jurors as referring to insurance, and that's a big deal. He's, you know, you might not say it directly this way, but what you want to say is, this lawyer is directly challenging your authority, Judge. Then you want to go to how your case was prejudiced. You know, Judge, now that there's reference to insurance, what can we possibly do to get that out of the case? It's in the jurors' minds. We can't get it out. There's no way to cure that prejudice. They're all going to think my client's getting, you know, rich off of workers' comp or whatever. And now, so you got to explain how your case is prejudiced. And I want to tell you, I put this checklist together with a specific, or the handout together with the specific idea that you could actually carry this into trial with you. This is not something you need to memorize. You know, after a while, it frankly becomes second nature, but you could just bring this to trial with you. And when this starts to happen, you got your checklist right here. How your case is prejudiced. We can't get this out of the jury's mind. We can't unring the bell. That's the reason in Washington State, the cases go back 100 years saying you can't refer to insurance. You make your best argument. Then you have to explain, of course, how there's no way to cure the prejudice. You know, telling them to disregard it, Judge, we're all big people here. We know that doesn't work. There's no way for you to take this out of the jurors' minds. We need to get rid of this jury panel, pick another one tomorrow, and then let's get going. Because there's no way to cure the prejudice, we need a mistrial. Okay, again, I emphasize it's not going to be granted unless the conduct was really, really, really bad and there really is no cure for it and the judge gets it. And those are all a lot of big ifs that are unlikely to come to fruition. So that's the conclusion of your argument, although sometimes you might want to add an additional argument. You know, Judge, you might think it's enough to do a curative instruction, but that won't work for these reasons. You know, I'm using one hypothetical. There could be other violations where maybe there's some other curative thing. And you may even want to talk about other possible curative things. And we'll talk about that in a few minutes. But that's the basic outline of what you want to do as your opening shot. That's your first statement when the bad thing happens. And my preference is to not interrupt the opening statement of the defense, but to bring this up immediately after. The law in various states differs. So it might be in DC or in Virginia, it might not be such a great idea to wait till the opening's over. I leave that to you. But from a sort of jury perspective, I think it's better that you not be seen objecting to this stuff as it's happening, but wait till the opening's over. Now, when you make that statement, the judge is going to have some responses. One is, I don't see it that way, counsel. I don't think that was a reference to insurance at all. I think that was, a reference to his family or wages, or I don't know what it could be. I mean, it could be a million things. Some judges are dense. Some judges are sleeping through the defense opening. No judge wants to declare a mistrial. So one response is this was not a violation. Another response is no big deal. You're making a mountain out of a molehill. This was an indirect reference. I don't think most jurors got it. That's another response. Third response, they can give a stern lecture to the defense. Yes, this was highly inappropriate, counsel. Don't do it again. I don't think we need a curative, I don't think we need a mistrial. I don't think it had as much prejudicial effect as the plaintiff's counsel is saying, but don't you dare do it again. Or limiting or curative instruction. That's kind of their go-to place. If they believe, if you've got a conscientious, let's put it this way, if you have a conscientious judge trying to do his or her job, and you do have a violation of the motion in limine or some other legal principle, the judge's go-to place is a limiting or curative instruction, which again, we're going to get to in just a second. Your chance of mistrial, 0.001%. When I've talked about this issue live with audiences of judges, some of them, on the bench 20 or more years, ask how many have granted a mistrial in their entire careers during trial, one or two maybe. So don't worry that the mistrial is going to be granted. If it's bad enough that the judge thinks a mistrial should be granted, that judge is going to be very angry, probably going to give you your costs and attorney's fees. You're going to be in a much better position than letting the prejudicial thing just continue. So one way or another, the judge is going to deny your motion. That's kind of a given. So what is your response? All right, Your Honor, I understand, but I'm really worried, or I believe this is going to happen again. So partly what you're doing here is sensitizing the judge and educating the judge. This is not going to be a one-time thing, because if experience is any guide, the defense lawyer who's willing to do this once is going to be willing to do it twice, especially if a mistrial is not granted. So it's good to kind of sensitize the judge. Okay, but I think this is going to happen again. Now, you don't do that in a petulant way. You don't do that in a angry way. None of that really helps you. You do it in a very professional, statesman-like way. Understand your ruling, Your Honor. I'm just afraid we're going to be dealing with this again before too much time passes. Then you say, but I think at least if we're going to cure the prejudice that's already happened, we need a strong curative instruction. Everyone knows certain things are prejudicial. You can't unring the bell. All the language from your cases in your jurisdiction, you got to give a strong curative instruction. And as you make the argument for a curative instruction, you need to emphasize that that's not going to cure anything. This is like the least the judge can do, and you need to make it, this is the least you can do. That's what you're setting up. And then in the process, you say, everybody knows, repeated social science studies have shown curative instructions, the pattern instructions that we typically use in this situation are not effective. Social science has repeatedly shown if you want jurors to follow an instruction that's counterintuitive, like forget the fact that plaintiff has insurance or forget the fact that plaintiff has a burglary conviction, you have to tell them why they should follow the instruction and why that's a fair thing to do. And incidentally, for any jury instruction that's important to you, you need to tell the jury why that instruction exists, why it's fair, why it's the right thing to do. There was a time, maybe 40, 50 years ago, when jurors would just follow the law kind of reflexively because they respected authority and so on. They did, but today's jurors for sure, and I don't, probably it's been this way all along. People think for themselves, and they're going to do what they're going to want to do what they think is right. So you need to explain to them in the curative instruction why this is right, why it's right that they should disregard your client's burglary conviction or the fact that there's insurance. So that means you got to give the judge a different curative instruction, not the pattern. If you don't have a proposed instruction, and like I don't come to court with a proposed curative instruction, what you have to do is ask for time to write one. So here's how it goes. Your Honor, the defense lawyer made an argument just a few minutes ago that was counter to your motion in limine. He violated your motion in limine. Here's why it's prejudicial, et cetera, et cetera. Go through the template. And then you say, this is really serious. I'm afraid it's going to happen again. I understand your ruling. You say you're going to give a curative. A pattern's not good enough. Could I have a few moments to write out a proposed instruction, Your Honor? This is so important. And almost every judge will give you that opportunity. So you sit at the table and you write one out. And here's the template for a curative instruction. And I suggest bringing this to court with you as well. So in the instruction itself, you explain what happened or what could have happened. So let me just find an example from the materials I sent out to you. Now let's do this one. It's on page, I hope it's on page 10 of your materials. It's entitled Sample Curative Instruction Number 1. So explain what happened or what might have happened. So here's a quote from that instruction for those of you who don't have it in front of you. Before this trial started, I ordered that neither party would be allowed to refer to the subject of insurance. This is the law of the state of Washington for a number of reasons. The most important reason is that it's your job to decide whether defendant Jones breached a duty to Mr. Smith, and if so, what's fair compensation for any resulting injuries. So those decisions should not be influenced by sympathy, passion, or prejudice. Those decisions should be made the same regardless of the wealth or financial resources of the parties. That's the very bedrock of our legal system. Everyone gets treated the same. So here we are. I'm actually jumping, well, I'm reading it in the order it was written, but let's see here. So if you go down a few paragraphs, what you get is yesterday when Mr. Defense Lawyer asked Mr. Smith about insurance, this is based on a direct exam, but same idea for opening, he violated my order. What he did could be viewed as an attempt to get you to decide this case on an improper basis. I'm not going to allow Mr. Plaintiff Lawyer to ask questions or introduce evidence on this subject because as a matter of law, it is improper for any of us to take insurance into account until after the verdict is returned. So you're explaining, the judge is explaining what happened, explaining why it was wrong or unfair, explaining what the jury should do about it, and explain what the jury should do if that doesn't work. So for example, in the instruction I was just reading to you, it ends with, if one of your fellow jurors mentions this subject in deliberation, it's a violation of that juror's oath, and I ask you to send a note to me immediately alerting me to this. So you can read these sample curative instructions in your own time. It would be tedious for most of you for me to be reading and walking us through them, but that's the template, that's the idea. And then what I always try to do, at least mentally, if not writing it out, is having more than one version. You know, I write my strongest version. You want like the strongest reasonable version that you think would withstand appeal and that the judge might possibly give. You don't want an impossibly great instruction, because then it may get so polarized that the judge says, I'm just going to give the pattern. This is too much work. So you got to be within the bell curve of reasonableness, but you can be out on the edge of the bell curve. And then, you know, what typically happens with me when I do this is the judge crosses out a few words, rewrites a sentence or two. But what you're pushing for is to take the defendant's misconduct and actually use it to your advantage. If the judge actually gave an instruction, such as the one part of what I read for you in number 10, what the jury's hearing is that the defense lawyer violated the rules. It looks to the judge like maybe the lawyer was trying to cheat, trying to get the jurors to base their opinion on improper stuff because their actual case is too weak. All of that, great stuff for you. And actually now this violation of the motion in limine maybe is neutralized, but maybe even has turned into something good for you. And if it's not neutralized, at least some of the sting is taken out of it. The other, okay, let me leave it at that. The other thing to do with these instructions, or I'm sorry, the other thing to think about in addition to a curative instruction is to think about alternative relief. So for example, maybe by opening the subject of insurance, well, certainly by opening the subject of insurance, if this is true, you'd be able to argue to the jury, yeah, he did get workers' comp and he has to pay it all back if he wins. So the first $500,000 of your verdict is not going to the plaintiff, but to the workers' comp carrier. Maybe you want to explain that now. You know, again, it all depends what the violation was, what the fact pattern was. But think about, did this open the door? And as the cases get more complex, the factual issues and the legal issues often get more and more intertwined. So it may be by violating this particular order, the defense has really given you an opportunity to talk about something that was excluded by the judge on your side that you now think, you know, they've opened the door to. So think about that. Let's see here. Maybe because they've opened up this new area, you're entitled to more discovery. You know, maybe instead of attacking your plaintiff, maybe they said something about themselves. You know, what's typical in a lot of our cases is we'll file a motion. You know, we've asked for some discovery. I don't know, the secret formula to Coke or whatever. We've asked for some discovery. They object to giving it to us. And then in our motion to compel, we ask for a ruling that it either get compelled that they produce this, or that they agree, or I'm sorry, or that the judge issues an order that they can't talk about it in trial. Because that's always the fear, of course. You know, you're doing discovery because you're afraid there's might be some, you want stuff that's good for you, of course, but also trying to find out what might hurt you. So you make a motion, you say, please require them to produce this evidence. But if you don't grant this motion, please issue an order that they can't refer directly or indirectly to this in the trial. So now maybe they've referred to it in opening statement. You know, Monsanto Corporation has given $1 gazillion in charitable contributions to the Sierra Club over the years. Well, now maybe we're entitled to discovery about what they really have done with the Sierra Club over the years, or whatever. So further discovery, perhaps, a preview of the other side's evidence or testimony. You know, that usually comes further down the road. I put that in because I did a trial once where the other side just kept violating motions in limine almost every day. And the judge was tired of it and we were tired of it. a long story, which I'm not going to relate here, but ultimately we got an order that it's actually a stipulated order because the defense lawyer's pro hac vici was about to be revoked. And instead of that, we entered into a stipulation that said the night before they had to tell us what topics they were going to ask about, what exhibits they were going to use with the witnesses in the next day. So just another alternative type of relief. Maybe, because they're going this way, maybe you say, Judge, they can't be trusted. We got to draw the lines tighter. Think about doing that. Revoking pro hac, I just mentioned. Monetary sanctions, who wants those? That's like the worst. I mean, it's better than nothing, but other than that, doesn't do you any good. And of course, JNOV or new trial, which is where you may be heading if things go really bad. So that's what I've got on curative instructions. I'm going to take just a second to see if anyone wants to pop up questions in the Q&A on that before we turn to offers of proof, which is kind of the inverse of this problem. All right, seeing no questions, I will go to offers of proof.
Wait, you have one question.
Oh, okay.
I just saw.
Let's see if I can see it now.
I can just read it.
I see it.
Okay.
I can't, I don't want to take us off on what are some good motions in limine to ask for. That's going to be so fact dependent in your case. Basically what you look for is what is out there in the real world of the facts of this case that could come and hurt us. So for example, my client has a burglary conviction. It's 8 years old. He's been out being a good citizen for the last 5 years. The burglary conviction has no relevance. You should exclude it. So that's the kind of things that can hurt you that don't belong in the trial. That's what you want to do motions in limine on. So, and if people have questions about this later, like things occur to you, happy to talk about them later today, but I just wanted to give a pause to see if any questions did come up. Okay, so let me go then to offers of proof. So this is, like I said, kind of the reverse situation. In an offer of proof situation, you wanted to get some evidence in and the judge says, no, you can't. So there are a couple really important points about offers of proof. And I guess I should say, what is an offer of proof? Because most of us were not taught about them in law school. And, we hear the term bandied about, but basically an offer of proof is a description to the judge. If you allowed me to present Mrs. Smith as a witness, here are the 3 critical things she would say. Now, ideally, you would have put all that into your opposition to the defense motions in limine, if that's the way they came up. But often in the heat of battle, things don't get done in the ideal way. So what I'm saying about, so in a motion in limine context, if you're pushing back, it's helpful to actually use the term offer of proof with the judge in your brief. The defense has moved to exclude the testimony of Mrs. Smith, an eyewitness to the accident, because she would say that she has seen 7 other accidents at this intersection and the defense wants to exclude those. Let's say it's that. You want a section that says in your brief, it's actually titled offer of proof. If allowed to testify, Mrs. Smith would say A, B, C, D, E, F. It has more power, it's more persuasive, and it makes a better record. Written offers of proof are almost, I would say, are always more effective. They tell the judge you're really serious. In fact, the judge will assume you're setting her up. Judges don't get written offers of proof very often. So let's take, instead of a motion in limine context, let's take the idea that maybe this is happening in the middle of trial. You know, your Mrs. Smith was about to, you know, you ask her the question, you know, you've lived in the neighborhood many years. Have you ever seen any other accidents at that intersection? Maybe your case is against the city, for example. And on the fly, you know, the defense says objection, irrelevant. And then you say, Your Honor, it is relevant for, you know, maybe you have a bench conference. Your Honor, it's relevant for these reasons, blah, blah, blah. She would say she's seen 7 other accidents since she's lived here. You know, you make your legal arguments, the judge overrules you. Now's the time to go back to it. See, I think what a lot of new lawyers don't recognize is that in trials, a lot of times there are second chances, third chances, fourth chances, if you stay alert and flexible. So the fact that the judge said Mrs. Smith can't testify about these other accidents, or she can't testify about what the defendant said as he exited the car, or whatever it is, there's a good chance the judge doesn't understand the full context. The judge, you know, we live with the case, we know it inside out. The judge, this is a tiny little piece of his or her brain. They're not as engaged as you are usually. And so they may not understand what they're ruling on. So if you do, okay, so let's say Mrs. Smith's on the stand, the defendant objects, judge shuts you down. At the next break, you say, Your Honor, may I make an offer of proof about what Mrs. Smith would say? Let's say she's still on the stand. You know, we moved on to other stuff. I'd like to make an offer of proof of what she will say. 99% of judges will let you make an offer of proof out of the presence of the jury. In fact, a lot of them like that, because then they get a chance to make sure they got the decision right. So written offers, so you do an oral offer at that point, and maybe it'll work. A lot of times it does. Here's why it's relevant. But written are even better. Let's say you've got a bad judge. The judge says, no, I don't want to hear your offer of proof, or just brushes you aside, or it's a really, really important issue. Then go to your office over the lunch hour or over the evening and write out a written offer of proof. I will guarantee you the judge will take it more seriously if the next morning you show up, you file a written offer of proof, it gets their attention. They assume you're setting them up. They're going to be careful. Don't back down. Judges will try to get you to not make an offer of proof. The bad judges will, because, you know, they're insecure, maybe they're biased, whatever their reasons. They want the record to be as undeveloped as possible so that you don't have a chance to reverse them on appeal. So I have had judges say to me, no, you can't make an offer of proof. Even had one say, you can't file an offer of proof, but I filed it anyway. You can't back down. If you think you're right, the judge has made a mistake and it's hurting your case. I mean, I guess I should back up. If it's unimportant, move on. Don't fight over every little minnow that swims by you. But if it's a big deal, don't back down. Don't worry. You've got a right to make a record. So get your written offer of proof filed. Think about the tone, and you got some choices here. One tone is excusing the judge. You know, Your Honor, I didn't make it clear in our opposition to the motion in limine, or I didn't make it as clear as I would have liked, but Mrs. Smith is really a critical witness here for the following reasons. And so that's the excusing the tone judge. Or, you know, the defendant didn't really flag what they were planning to do, or, you know, how they were planning to object or whatever. So one tone, excusing the judge. You all know how to do that. One is kind of a neutral, very factual tone. You know, this happened, you issued this order, we did this. Here's what this witness would testify to. Here's why it's relevant. Very neutral, matter-of-fact tone. Now, you can also do a tone of pointing out the judge's unfairness. And sometimes that's called for. Usually not, but sometime, the court sua sponte objected on its own to the testimony of Mrs. Smith without any objection from the defense. Plaintiff's counsel, the undersigned, offered to ask to make an offer of proof. The court refused to let us do that. As a result, the record is woefully inadequate. So you can point out their unfairness and kind of get in their face. So you got to think about what tone are you going to use. So here's the template for an offer of proof, regardless of the tone. What happened before and why the situation has changed or why the record is inadequate. In other words, at the beginning of this trial, you ruled that there could be no evidence of insurance. But in opening statement, the defendant said XYZ, which opened the door to insurance. And so now the situation has changed, and we should be allowed to tell the jury that, yes, there was workers' comp insurance. There is a lien. The plaintiff's going to have to pay it back. That's the only way to get rid of this unfairness at this time. So you explain to the judge, this would be consistent with the tone of excusing the judge. Yeah, maybe your decision to exclude this evidence before was the right decision, but the situation has changed and you need to change your ruling as a result. And the law in every jurisdiction I've ever seen is that motions in limine orders are subject to change throughout trial depending on circumstances. Then what you would present if allowed. So this is the meat of the offer of proof. If allowed, Mrs. Smith would say XYZ. And the reason I put on the outline realistic fantasy is this. Any experienced trial lawyer knows you never really know what's going to come out of a witness's mouth until they actually say it. No matter how good or how bad they are as a witness, they can and will surprise you. So ethically, it has to be a realistic fantasy. You can't say Mrs. Smith is going to say she read a memo from the city department saying they don't care about accidents at this intersection if you've got no basis to think she would say that. But if she says, I saw 7 other accidents there and they all looked very much like this one, put that in. And maybe she's not the greatest, most articulate witness and you're kind of afraid she may wobble. Well, you don't have to put the wobbling into your offer of proof. So it's like, if the stars are aligned just right, and this witness does an A+ job, what's likely to come out of their mouth? Then, of course, why it's fair and relevant to allow the evidence in. One of the best ways to do this, which I pound on the young lawyers in our firm about this, I harp on it in CLEs. You want to tie your legal arguments when you're arguing to a trial judge. You want to tie your arguments to the jury instructions and the elements of the claims or defenses as often as you can, and you almost always can, because if you think of the trial judge's job, most of them are juggling lots and lots of cases. They're overworked, they're unfocused, they're doing the best they can. And for them, pattern jury instructions are a safe haven. They don't have to go look up the law and read the cases and figure out if you're accurately summarizing the case or accurately quoting it. Just quote them the pattern jury instruction. One of the elements of our claim is that the city was negligent. And under the pattern jury instruction, the jury's allowed to consider X, Y, and Z, and this is X, and this is Z, and therefore you should let it in. So whenever you can, tie your legal argument, especially as it relates to offers of proof, to the elements of the claim. Look, Judge, this evidence that we're offering that you just excluded goes directly to element 3 in our cause of action pattern jury instruction, or it goes right to the affirmative defense the defendant has raised. So, you know, that may be the most important thing I say all day, and most of you will ignore it, but there you go. That is probably one of the most effective ways to get trial judges to do what you want, which is to show them the pattern jury instruction and show them that what you're asking for is consistent with that. And of course, there may be other legal authority in that regard. And so now that's offers of proof. Let me see what else I got here. Yeah, so Trial Guides likes me to put this slide up. If you use this promotional code, RFCLE, and order one of my books or DVDs or whatever, you can, you have to just type in RFCLE and they'll give you 10% off. So now I think I stopped screen sharing. Is that right, Mary? Did I do that?
Yes, you did.
Okay, great. Getting good at this.
You are.
All right. So let's see if there are any questions about that section. And doesn't look like there are. And I guess also anyone should feel free. And actually, I'd ask, could somebody raise a hand and just see if we can get you talking? You don't even have to have a question. We're just going to do a quick little test here. Someone in the audience would just raise a hand.
Yeah.
And then
Hold on. Yes. And as a matter of fact, you can, I'm looking for the person who raised it. Oh, let me see over here. You can allow people to talk. So we can do that. Do you want to, you know?
Great.
I'm gonna let Karen Evans just say a word. Just we're testing it. Go ahead.
Looks like she's muted still.
No, she isn't.
How about now?
You got
Excellent.
it. Okay.
Thank you, Karen. Thank you, Karen.
We'll go through it. We'll do
All
it
right.
right from now on. If we
Yes.
want to be able to have people ask their questions, Rick, if you prefer.
I think it's a small enough group. I think it's a small enough group that it's worth trying that. And so here's it, in the next minute or two, if nobody raises their hand and has a question about the material we just went through, at that point, I will switch topics, and maybe it makes sense, Mary, to take our break now, and then we could go uninterrupted or with one very short break between now and the end. Does that make sense?
Yep, that makes total sense. So
let me just announce that what we'll do after the break is we're going to kind of dig into the secret weapon that every one of you has that you may not have thought about, and some of your kryptonite, if you will, the things that can trip you up that you maybe not have thought about as well. So now I'll shut up and go ahead, Mary.
Okay. So folks, we're going to take, what do you think, Rick? 10 minutes? 8 minutes?
So you said you needed that, right? You needed a 10.
That's true. Thank you for keeping me on point here. So two things I need to do before I go on. I want to give a shout out to Joseph Gonzalez of Physicians Life Care Planning. I did not see him there, but thank you for being a longtime Diamond sponsor. And the other thing I'm doing, well, first of all, very important, Rick's book. Okay, this is a phenomenal book. Get it, use the 10%. If you need the code, I'll be happy to give it to you. I'm sure it's showing up backwards. I feel like it is, but.
No, it's not.
It's not? It is to me.
Yeah.
Anyway,
Okay.
so
And thank you, Mary. Mary, just so you know, for reasons that have to do with my computer, I am going to shut down my computer and come back in about 5 minutes.
oh,
Is that
okay.
okay? Is
That's
that
fine.
okay?
I'm
All
just
right.
doing
Thanks.
housekeeping stuff.
Yeah, that's what I figured. Thanks.
Okay, and then folks, we're also giving away this book as a raffle. This is not Rick's book, but it's Digital Marketing for Law Firms. And I'm just going to go ahead and randomly, and I mean randomly, pick one of you to win this book. And that person is going to be Alan Siegel, has won this book. So Alan, I will mail this over to you. Hopefully you heard me say that. And then finally, I'm going to go ahead and play our sponsor reel with all our sponsors on it. And you are more than welcome to take a quick break while you're listening to that. And there you have it. Come back in about 5 minutes as I figure this out. Don't mind me. All right, here we go. I have figured it out. No, share this. Let's go here. Let's go. I have too many things on my screen. Close that. Move that. Make that big. Play. Perfect.
We are Planet Depots, headquartered
There's no sound, Mary.
Medicare secondary payer compliance services, public benefit preservation mechanisms, including pooled special needs trusts and Medicare set-asides, settlement asset management trusts, comprehensive settlement planning and consulting services, tax deferral mechanisms for trial lawyers, qualified settlement fund administration, and mass tort lien resolution services.
At CED, we serve the legal industry as forensic engineers and expert witnesses. We explain the science in your case and base our opinions on standards and engineering. The company was formed 30 plus years ago by a group of Naval Academy professors. We continue to hire staff with engineering disciplines including mechanical, civil, structural, electrical, material science, and biomechanics to answer the injury causation question.
Furthermore, to ensure that all of our experts and their work product meet our high standards, we incorporate various quality controls such as collaboration amongst the engineers, technical review of all of our written work product, and mentorship.
To find out more about our expertise or our informative webinars, visit cedtechnologies.com. Thank you.
at Capital Healthcare and Maryland Healthcare Clinics. We specialize in treating patients who have suffered automobile or work-related injuries. We have more than 60 locations across DC, Maryland, Virginia, and Delaware. We are a full-service facility offering care for each stage of a patient's treatment, including internal medicine, orthopedics, neurology, physiatry, psychiatry, physical therapy, and radiology. At Capital and Maryland Healthcare Clinics, all services are offered in-house, which gives us maximum flexibility to provide the highest quality medical treatments. our patients' speedy recovery is what keeps us going. Therefore, we strive to make the treatment process easy and effective so that our patients can heal and recover as best as possible. Our attorney portal allows you to schedule same-day appointments, securely access your patient's medical records, HIPAA compliant, exam results, and itemized bills. We are fully open for business and working diligently to keep our patients and staff safe by following all the necessary guidelines recommended by the CDC and government officials. For more information, please contact Nagora at 301-906-6941.
Hello, everyone. I'm Joseph Gonzalez with Physician Life Care Planning, and I'm speaking to you from Philly, where bad things happen. We're very pleased to continue our sponsorship of the Trial Lawyers Association of Washington, D.C. during these uncertain times. I'm excited to report that during this off-season, Physician Life Care Planning has continued to work on our goal to provide credible, convenient, and high-quality damages valuation services for our clients. This includes adapting our practices to create safe environments for staff, experts, clients, and claimants, creating working relationships with fast funds and fast case support to work seamlessly with attorneys and firms which may need to access working capital for case expenses. We've also added physician life care planners in Maine, Massachusetts, Wisconsin, and Virginia, giving us a nationwide footprint of over 70 associate physician life care planners. This includes the addition of Dr. Albert Jones, located in the Richmond area. We've also added Atlanta-based forensic economist, Dr. Nick Volkov, and vocational and rehabilitation specialist, Despina Vugiakis of Spark Hill, New York. This will allow us to better serve your medical and related damages valuation services needs. And to close, I want to thank all of our Metro DC clients for your continued trust and support. We truly appreciate all that you do and all of the work that DC TLA does for the legal community and public. Thank you very much.
I'm Dr. Chuck Thorne, co-managing member of Multi-Specialty Healthcare. For the past 27 years, Multi-Specialty has been the premier provider of quality healthcare services to those involved in personal injury and workers' compensation cases, with 34 care centers throughout Maryland and Delaware,
Frederick, Montgomery County, and Washington, D.C.
High-quality, patient-centric healthcare services. We understand the needs of our patients and the law firms that serve them. All of our care centers are conveniently located, and we provide transportation when necessary. We offer a HIPAA-compliant attorney web portal to access all necessary medical records and bills. We're available for expert depositions and trial testimony. As a result of the COVID pandemic, the need for virtual hearings and trials has risen dramatically and looks to be here for quite some time. The multi-specialty portal makes it easy to obtain all necessary documents for trier of fact. For those of you whom we've worked with to date, we thank you and look forward to continuing and building our relationship. For those we have yet to serve, give us a try. We look forward to working with you in the near future. We're Multi-Specialty Healthcare, where quality injury treatment is no accident.
Does your case have any outstanding medical bills or claims for reimbursement by a lien holder? Are you looking to maximize the settlement funds for your client? At Metavest, we're here to help. We offer a wide variety of lien investigation and resolution services to help protect the settlement funds. We specialize in Medicare, Medicare Advantage, Medicaid, VA and TRICARE, FEBA, ERISA, hospital, and private healthcare liens. Metavest has the knowledge and experience to navigate the complexities of lien resolution. Your time is valuable. Let us help you make the most of it. We offer free case consultations, so please don't hesitate to contact me directly at 949-632-0029 or via email at cpauley@metavest.com.
Now you can finally feel more organized and at peace with your trust accounting. Spend less time managing your accounts and more time practicing law. Your world is changing fast. Don't you think it's time your trust account management changed with it? Nota, banking built for lawyers.
Okay, thank you. Let's see how I do this. Hopefully everyone's still there. Yes, they are. Hello, everybody. Can you hear me okay? Okay, Karen, looks like you're one of our squares for the rest of the time somehow. I have no idea why, but anyway, I'm going to turn it back over to you, Rick. I don't think I forgot anything else, but thank you everybody for staying with us. And without further ado, back to Rick.
Thanks, Mary. Now we're at the part that I personally find most interesting, and the real part I find most interesting is having discussions with you guys when my little piece is done. You know, over time, trying a lot of cases, I began to realize that something was going on in the courtroom often, not always, but often, that could not be accounted for by the skills of the lawyers or even the facts of the case, or at least not fully accounted for by that. And what I began to recognize is that in some cases, something was going on that law school didn't explain, and CLEs didn't explain. And, you know, sometimes the best lawyer and the best facts were not winning. And sometimes I was the one who was not the best lawyer and didn't have the best facts and was winning. Sometimes I was losing to people who did not have the best lawyers or the best facts. So I began to pay more and more attention to that sort of thing. And what I'm going to do, I'm not going to walk you through my thought process, but ultimately, you know, I stumbled across something that Aristotle supposedly said. He supposedly said that there are 3 types of persuasion open to an advocate. And one type of persuasion he called logos, or logic, which, if we didn't learn it before law school, most of us learned a lot about logic in law school. The second type of persuasion he talked about was pathos. And by that he meant, as best I understand it, what already resides in your audience, what's already there before you even show up. So for example, if you've got a tractor trailer case and you step into the courtroom and you have a jury panel and there's a person who has had a family member killed by a tractor trailer, that person already has something inside them that's probably going to favor you in this case. Or, you know, I tried a lot of cases in Appalachia on behalf of coal miners. Well, if you're representing a coal miner in Appalachia, you've got the wind at your back. There's something already in the audience ready to receive you and go with you on your case. So the reptile, for example, is an approach that tries to figure out, among other things, what's in the audience already and how to use that to your advantage. And, you know, there are trial consultants who will tell you about that. There are tons of social science studies about what already resides in your audience and how to use that to effect, how to bring it up, how to harness that energy that's already there. But then there was a third type of persuasion available to the advocate that Aristotle called ethos. And I think that comes from the Greek root ethikos, which I don't even know if I'm pronouncing it right, but meaning moral, showing moral character, showing moral rightness. And his view was that the messenger, who is the deliverer, who is the persuader, often has as much or more power than logic or pathos. And these are kind of simplistic definitions, but they're enough for our purposes today. And what struck me as I was thinking about that is we're never taught anything about ethos. The most I remember hearing and reading about over the years is, trial lawyers would say, your credibility is the most important thing. Trial is a battle of credibility. Never lose your credibility. And then we say, well, how do I get credibility? And we're told, be prepared and be honest and don't overpromise in opening statements. And, more recently in the last 20 years, be authentic, be who you are. But, what if who you are is a jerk? What if who you are is not that pretty to look at? Most jerks don't know they're jerks. And most of us are not our best selves in the courtroom. At least we don't start off that way. And that got me thinking about Jerry Spence's comment that I'd heard him say at CLEs numerous times. He'd get up and he'd say, anybody in this room can beat me. The least experienced lawyer here could beat me in trial if they can just be more real than me. Which I thought that was hyperbole at the time, but I've come to think that what he's getting at is this concept of ethos. Who is the messenger? One of the best trial lawyers, certainly the best trial lawyer I've ever seen in action, and maybe the best trial lawyer I've ever seen, period. It's a guy named Jim McComas, who actually was head of the DC public defender, not head, but I think he was training director of the DC public defender's office years ago. Really extraordinary lawyer. And I'm going to screen share again if I can. Well, no, I'm not going to do it because I think that'll get us off track. But anyway, what Jim wrote to me in an email once, he said, the sincerity of a true heart is the only requirement of effective advocacy. No one wants to know that because a true heart is so much harder to acquire than a few advocacy techniques. What Spence and McComas are getting at, I believe, is this concept of ethos, that there's something that resides in each of us that, if tapped into, can make us a powerful advocate. And most of us are not really comfortable tapping into that for various reasons. And without question, somebody can be a very successful lawyer without, quote, tapping into their ethos. And without question, an advocate with ethos, as I'm kind of trying to define it, can certainly lose cases. This is not like some magic bullet, but I do think that there is an aspect of ourselves that goes largely ignored, or maybe not ignored, but neglected, that I think can be taught, can be cultivated. And so that's what I'm hoping we'll do a little bit of today. And so I'm going to ask you all, this is honor system because I can't see you all, but I'm going to ask you all to close your eyes, just sitting at your desks or wherever you are. And we're going to do just a little bit of an exercise. I'd like you to close your eyes and think about a case you lost, a very, the most important case that floats to your mind. that you lost. And maybe, you know, a day from now, you'll think, oh, it wasn't the right case. There's no right or wrong here. Just pick a case that really hurt to lose. Close your eyes and think about being in that courtroom when you lost. And so you're sitting at the table next to your client. The buzzer rings, or the door knocks, or the bailiff says the jury has a verdict. I always start to sweat even just talking about it. And the jury files in, and you're looking really carefully to see who has the verdict form, because that'll tell you who the foreperson is. And you're looking at their faces, seeing if you can get some sign of who it is that, or what the verdict is. And the foreperson hands the verdict to the clerk or bailiff, who hands it up to the judge, and the judge is reading it, and you're studying the judge's face for any clue of what the verdict is. Yeah, and then the verdict is read, and you've lost. And it's a great day for the defense lawyer. It's a terrible day for you. You probably have costs that you're never going to recover. You've got to go explain to your client the consequences of the loss and the hopes on appeal, and maybe there isn't much hope, or, you know, it's a bad time, you know, how bad that feels. And meanwhile, the defense lawyer is going to be going off celebrating with the adjuster or whoever his client is, and drinking champagne and whatever those people do when they have a good time. And so, keeping your eyes closed, I ask you to think about if you could go back in time and change places with the defense lawyer on that day, in that moment, and you'd be the one who just won a case. You just defensed the plaintiff. You're going to get more work. It's a great step in your career. Your friends are going to congratulate you. How many of you would change places with a defense lawyer on that day? And I've probably asked, usually we do that live in front of a live audience, probably asked over 1,000, maybe 2,000 lawyers that question over the years. And only about 2 or 3 have raised their hands. One didn't understand the question. One had a case in which, you can open your eyes now, by the way. One didn't understand the question. One had a client who he found out mid-trial was a total fraud and liar. And the third was someone who, you know, could just as comfortably be on the defense side as the plaintiff side. And, you know, truly didn't matter to him. It was, you know, trial was kind of like a sport. And so he just wanted to be on the winning team, and that was pretty much it. I want to suggest to you that this is your secret power. This is the thing that for most of us gives us a power that the defense doesn't have. You know, we get to choose our cases. We get to choose our fact patterns. We don't have to go to trial on a case that we don't believe in. Sometimes we do because of circumstances, but by and large, we get to be in there fighting for something we believe in. And I'm not suggesting that self-righteousness is our secret power. I'm suggesting that being right is our secret power. Our clients do deserve to win. And deep down, we know that. And so part of my book is devoted to kind of how to cultivate that moral power that is available in almost every case for us. But what I want to spend most of since we have limited time here, I want to spend most of my time on your secret Achilles heel, or your secret kryptonite, whatever you want to call it, the baggage that you take into the courtroom that can trip you up and create serious, serious problems for you. We all have that to some extent. We all have baggage, whatever you want to call it, psychic wounds, histories, neuroses, whatever you want to call it, that we bring into the courtroom with us. And if it's triggered, can cause us problems. So how do you know what your problem is? Because generally we're kind of blind to our own, we're blind to our own weaknesses to some extent. So here's a clue to finding your own kryptonite, shall we say. You know, think about if there were a classified ad for our job. Wanted. Lawyer willing to work in a competitive, hostile environment. Must be willing to interact on a daily basis with other lawyers whose job it will be to make sure that you fail. Sometimes those interactions will be in person, sometimes by phone or email. Those interactions will be constant, every day. Must be willing to work many nights, weekends, and holidays, reading, assimilating, and producing mountains of paperwork. Occasional trials will be required. During trials, expect to work 16 to 20 hours per day and battle your opponents in front of 12 strangers and a judge who may have the inclination to help you lose. The stakes will be high. If you lose, ... So I ask you, who would be attracted to that job? And I'm going to answer that question. I think to a large extent, people who are attracted to that job are wounded people. And obviously I'm including myself in that same category. It is what attracts us to the job, that is, our wounds attract us to the job, but they also trip us up. You know, the most simplistic way to think of this, and it is simplistic, but you know, if I were bullied as a child, then maybe I want to stand up to bullies as an adult. And so I pick a job that gets me into court where I can stand up for the underdog and fight bullies. Very simplistic, but you know, there's truth to that for a lot of us. So I think what I will do is tell you all a story. It's one of my favorite stories of all time. A police officer is walking through a city residential area late at night. It's a windy, rainy, cold, nasty, dark night. And he's walking down the sidewalk and he sees a man under a street lamp on his hands and knees on the sidewalk, like he's searching for something. So the police officer comes up to him and says, what are you looking for? And the guy points over to the house, right to the side of them, and says, I lost the keys to my house. The police officer looks over at the house and it's this beautiful brick house, and he can see through the windows, there's lace curtains, a warm fire burning in the fireplace, a table set with candles on it, fine china. It just looks like the most cozy, comfortable place in the world. And the police officer gets down on his hands and knees and starts looking for the keys as well. After about 5 minutes, the police officer says, well, where do you remember last having your keys? And the man says, he points to the side of the house. He said, I dropped them in that dark alley down there. And the police officer says, well, if you dropped the keys in the dark alley down there, why are you looking over here under the street light? And the man says, well, the light is much better here. When I first heard that story, I thought, oh, that's a funny joke. But I think there's a ton of wisdom in that, because the lesson I take from that story is we are all comfortable looking for answers in places we're comfortable looking for answers. But if the answers were in places we were comfortable looking for them, we would have found them a long time ago. That's kind of a sobering thought when you think about it, that the answers are not where I want them to be, where I hope them to be. They're in the yucky places that I just as soon not pay attention to. What a drag that is. But I think it's true. And so as trial lawyers, if we, well, let me say it this way. If we don't develop ourselves, if we are not willing to look into the dark places of ourselves, those dark places will trip us up. And I'm going to just share a couple of my favorite quotes with you, and then we'll get right down to it. I like this quote from Daniel Gilbert, who's a psychologist. Human beings are works in progress that mistakenly think they are finished. And we could substitute lawyers are works in progress that mistakenly think they're finished. And then this is from somebody whose name I'm afraid I can't pronounce well, and I'm going to mangle, Yongey Mingyur Rinpoche, who says, ultimately, happiness comes down to choosing between the discomfort of becoming aware of your mental afflictions and the discomfort of being ruled by them. And I venture to say, when all of us got our bar license, we were ruled by our mental afflictions. And the question is, being ruled by our mental afflictions, well, let me say it this way. If we are ruled by our mental afflictions, let me start over. To the extent we are ruled by our mental afflictions, we are not the trial lawyers we could be. So I don't think any of us ever get to the point where there are not mental afflictions that are having their way with us and at times. But there are ways to explore our mental afflictions, our blind spots, our dark alleys, and emerge from this as a stronger advocate, as a better messenger, as a better teacher. And one of the best ways to do that is through therapy, which I try to mention in every single CLE I do. And so now I'm mentioning it now. You know, Jerry Spence spent decades in therapy, both individual and group. And then when he started the trial college, he made a particular type of group therapy kind of the foundation of the whole trial college. Mo Levine, way back in the 60s, talked once, I probably never mentioned it again, but talked once at a CLE about how he had had 4 years of therapy and how it had made him a better person and a better trial lawyer. My opinion is no matter how good, experienced, or comfortable you are as a trial lawyer, you will become better if you go to therapy. And I'm just going to read you this quote from Carl Rogers on becoming a person, from his book On Becoming a Person, when he's addressing the benefits of therapy. He says, the person comes to see himself differently. This is all he, of course, because he's writing in the 60s, but the person comes to see himself differently. He accepts himself and his feelings more fully. He becomes more self-confident and self-directing. He becomes more the person he would like to be. He becomes more flexible, less rigid in his perceptions. He adopts more realistic goals for himself. He behaves in a more mature fashion. He changes his maladjustive behaviors, even such a long-established one as chronic alcoholism. He becomes more acceptant of others. He becomes more open to the evidence, both to what is going on outside of himself and to what is going on inside of himself. So let me read that last sentence again. He becomes more open to the evidence, both to what is going on outside of himself and to what is going on inside of himself. Now, what trial lawyer wouldn't want that? So there are other ways to investigate, and I'm not going to go through them all now. You know, there's meditation, there's yoga, there's various types of self-styled introspection. But the paradox here is the work of getting at this stuff to make yourself a better advocate. Only you can do the work, but you can't do it alone. Because what we're really talking about is human relations, right? That's what persuasion's all about, connecting with someone else, influencing and persuading them. That's a human relation characteristic. You can't practice. I think of the, I guess it's not good to quote Woody Allen movies anymore, but I think it was Love and Death back in the 70s, maybe. He's just had this phenomenal sexual encounter with some woman, and she just said, she's just blown away. And she said, "How did you ever become such a great lover?" And he said, "I practice a lot while I'm alone." You know, you can't practice persuading people alone. You can't practice connecting people alone. You can't be alone and develop your abilities to persuade. So that's now we're going to focus in on one topic, because it seems like it cuts across every lawyer I know, and that's fear. You know, because we can't go into every dark alley today. We only have a certain amount of time, and this format is not conducive to going into every dark alley either. But we can, I think, take a little swing at fear today. I consider myself an expert on fear. First roughly 15 to 20 years of my trial life, I would throw up almost every morning during trial. The next 10 or 15 years of my trial career, even when I wasn't throwing up, and as I was getting more comfortable in the courtroom, I would hold on to my fear. I fanned the flames of my fear. I thought I needed my fear. I thought it was helping me. I thought, I thought that without my fear, I would lose my edge. And it's interesting. There's a quote from a book called "The Body Keeps the Score" by Bessel van der Kolk. The body keeps the score. And he says, he's a doctor who studies trauma. He says, "Many traumatized people seem to seek out experiences that would repel most of us. And patients often complain about a vague sense of emptiness and boredom when they are not angry, under duress, or involved in some dangerous activity." Now, I wonder how many trial lawyers you could say have a vague sense of emptiness and boredom when they're not under stress, not involved in some trial is a dangerous activity in its own way. You know, when they're not angry, stressed, combative, when they're just sitting quietly at peace. How many lawyers feel a sense of emptiness and boredom or restlessness? I know I did. I know it can still come up upon me at times. Well, if you've got that, that's a sign of trauma. And people who have had trauma in their lives, many of them don't even know it because it happens in childhood, have a particular reaction to fear. They have trouble consciously or unconsciously distinguishing between fear in the present and fear in the past. So let me come at it this way. We can think of fear as an energetic response in the body warning us of danger, right? So my mouth goes dry. I start to sweat. Maybe I tense up. My breathing becomes shallow, or maybe my breathing becomes faster. The body is energetically responding to fear. So, okay, it makes sense. Like, and those who are interested in this, a really fun book to read is Why Zebras Don't Get Ulcers, which talks in great detail about the biology of fear. But, you know, the bottom line is it makes sense. A lion comes charging through my conference room door. Yeah, my mouth's going to go dry and all sorts of other reactions are going to start to take place. Well, that's fine if a lion's charging through the door, but what if I'm just walking through the courtroom door going to trial? Are all those same bodily functions and reactions helpful? Probably not. Some trial lawyers try to ignore fear, just brush it aside or repress it. Others try to make friends with it, like I did. You know, they think the fear energizes them and is good for them. And, you know, to some extent, that's true. Like if you're at 2 a.m. preparing a cross-examination in the middle of trial, fear can keep you going, can give you adrenaline. It can be a super strong motivator. It can keep you going for another couple hours while you finish that cross-examination. But numerous social science studies demonstrate that actually our abilities to perform well are impaired by fear and by stress. We don't make our best decisions when we're afraid. You know, yeah, if you're afraid and need to lift a car off your child when it's fallen on her, fear may be a good thing. But if you're going into court, making arguments to a judge and a jury, trying to connect with people, because the other thing fear does is it makes it harder and harder to, and stress as well, makes it harder and harder to connect with people. So, yeah, and emotions are contagious. Jurors can feel your fear, even if you're trying to hide it. A fearful jury is not likely to be a plaintiff's jury. So we got to come to terms with this. Plus, fear feels terrible, doesn't it? Like all those bodily reactions to fear, I can't think of any of them that are pleasant. So let's drill down on fear. And if you've got a pen and paper, I would suggest you just kind of make a list here, and you can continue it later on when you're alone. But make a list of the things that you think of as you. You know, if you think of yourself walking into the courtroom, who are you? And this is not philosophy. This is like practical. I don't know what to call it, but you know, you're not going to be tested on this. You're not going to be questioned about it. But who is you that's walking into the courtroom? Well, you know, so I'll do me. You know, okay, it's my body, you know, my physical presence. There's my brain, my intellect. There's my heart, which I think about as my capacity to love and connect with people, my ability to feel various things like compassion and joy. There's my values, you know, what I believe in. And you make a longer list. Those are the kinds of things. Make a list. And the things that give you your sense of self. And when you're done with a list, ask this question: which of the things on my list can be hurt in court or during a trial? You know, not many lawyers get physically harmed in a trial. You know, I'm going to come out with all 4 of my limbs. My brain's going to be intact. My heart's going to be intact. I may have some feelings I don't like. My ego may take a hit. You know, I thought I was a great trial lawyer and I just lost a case, which I do with some regularity. You know, those kinds of things. But the truth is, It's not like a lion crashing through the door. Walking into the courtroom, we're not going to get hurt. So exactly what are we afraid of when we walk into court? Again, we're not walking into combat. We're not going to get shot. We're not going to get killed. So why are we so afraid? So there are three, in my mind, three common types of fear, which I think of as vicarious fear, self-image fear, and historical fear. Vicarious fear is kind of like this. I'm afraid there'll be a bad result for my client. I care so deeply for him that I fear for him. Now, that's not an irrational fear. You know, bad things happen to our clients in courtrooms. I mean, they don't get killed either unless it's a death penalty case, but bad things happen. They lose cases. They lose the opportunity to get money that will help them put their lives back together again. They get embarrassed. They get humiliated. Bad things happen to our clients in the courtroom. So it's not a irrational fear to fear for your client. You care about your client. You're supposed to be protecting them, helping them. Of course, you have some amount of fear for your client. But while it's a rational fear, I want to suggest to you that it's not a professional fear. You know, think of being in a hospital and the night before your surgery, and the surgeon comes in and says, how you doing, Rick? And I say, well, I'm a little nervous, but I think it's, you know, I'm okay. And the surgeon says, well, that's good. And then I say, well, but, you know, doctor, you look, I don't know, you look different than the last time I talked to you. Is everything okay? And the surgeon says, well, yeah, everything's fine. I'm all ready for this surgery. I'm really well prepared, but I just care so much about you that I'm worried that something could go wrong. And it's got me kind of nervous and fearful because I care so much for you. Most of us would not find that reassuring. We want our doctors to care about us and for us, but we also want them to have a certain amount of professional detachment. But care doesn't have to equal fear. Of course we care, but of course also there are all kinds of things that happen in a trial that are outside of our control. And so the case can be lost for any of a number of reasons, having nothing to do with us. And, you know, one way of dealing with this kind of fear, I would suggest, is to recognize that something bad happened to our client before we ever met them. You know, they were arrested, they had a car crash, they were fired for discriminatory reasons, whatever it is, the bad thing happened, and then they came to see us. We did not cause the bad thing to happen. Our job is to see if we can lift them up, so to speak. We can, you know, just like a surgeon, you know, someone comes in with a broken leg, surgeon didn't cause the broken leg. Surgeon's going to try to put the leg back together as best he or she can, but that's kind of the end of it. And maybe they can, and maybe they can't, and maybe it'll be a halfway job. Same with us. We are not God. We cannot make everything right. We can hopefully improve the situation. But what I see is a lot of lawyers use the vicarious fear for their client to cover over their own fears. In other words, way easier to be afraid for my client than to be afraid for myself. And so, you know, that I can't, you know, we've all seen the lawyers. I care so much about my client, which, by the way, shows what a great person I am. I care so much about my client that I am paralyzed with fear. I am, you know, having sleepless nights and I tremble when I walk into the courtroom because I care so much about my client. Well, that's way easier to deal with, even though it's dishonest, can be dishonest, when it's there to cover up our own personal fears. So what kind of personal fears do we have? The next category of fear, I would say, is what I would call a self-image fear. And the self-image fear has its own 3 subcategories, as I think about it, or 3 types of self-images, let's say. There's how I would prefer to see myself, and my self-image in the courtroom, my preferred self-image, let's call it, is, I've got the power, the presence, the charisma of Jerry Spence. I've got the elegance and nobility of Atticus Finch, as played by Gregory Peck in To Kill a Mockingbird. I've got the world-weary wisdom and understanding of Spencer Tracy, or what his character was in Judgment of Nuremberg. I'm just like the perfect trial lawyer. Just this self-image that I hold, or used to hold, that's my goal. That's my aspiration. That's what I want to be. That's who I aspire to be. Well, that self-image just takes a beating within about the first 5 minutes in the courtroom, right? It's just, it's a fantasy. It's an illusion. It's never going to happen. And if you doubt this, go and read some trial transcripts from whatever trial lawyer is your hero. And what you'll find is the very best trial lawyers are, kind of underwhelming most of the time in trial. You'll certainly see flashes of brilliance and really cool ideas that you'll want to utilize yourself. But mostly what you'll see are regular people going to court, hammering on the facts that help them, trying to explain away the facts that hurt them, doing their best to persuade, talking in incomplete sentences, getting chastised by the judge, and getting, sometimes phenomenal results and sometimes mediocre results and sometimes losing. So if these trial gods can't pull off the idealized performance that lives in all of our minds, what hope do the rest of us have? So this fear that we won't measure up to our idealized self, our preferred self-image, I think is shared by just about every trial lawyer. So it's a very reasonable fear, but frankly, it's ultimately an immature fear. Maybe we could let that one go. Maybe we could recognize that we're all just people doing the best we can in the courtroom. But there's another self-image, I think, that's also at play for most of us in the courtroom. It's what I call my pitiful self-image. Deep down, where I don't want anyone to look, especially not you guys, there's a pitiful self-image. It's a weak, awkward, ugly, unlovable self. It's an inarticulate, inarticulate, awkward keeps coming to mind, self. No one wants a weak, awkward, ugly, unlovable lawyer. No one wants to be a lawyer like that. And the fear here, of course, is that the trial is going to confirm that pitiful self-image, that we're going to stand up and we're going to make a mistake. Someone's going to see through us right down to that core of our worst perception of ourselves, which of course is just as unrealistic as the Spencer Tracy, Jerry Spence, Atticus Finch self, just in the other direction. But I would suggest that many, if not most trial lawyers, somewhere deep down inside have that fear that this is the trial that's going to reveal that self-image. And part of dealing with that fear is coming to terms with the idea that all lawyers make mistakes, and that those mistakes don't define who we are. I mean, some of the trials where I've made the worst mistakes have been ones that I've won. And some of the ones that I think were my most perfect trials, I've lost. And the truth is, what we call mistakes at trial often go unnoticed or loom much larger in our own minds than in anybody else's minds. And the other truth is that every trial lawyer at times in court looks foolish, weak, awkward, inarticulate. You know, if you can't tolerate looking foolish, weak, awkward, inarticulate in front of other people, you got no business being a trial lawyer, because that's going to happen sooner or later. And all that energy that we spend either trying to prop up the idealized self-image or trying to protect so nobody sees the pitiful self-image, all that energy could instead be put into winning our cases, connecting with jurors, dropping the idea, you know, here's the paradox, and it is a paradox. We are the most important person in the courtroom, and we are the least important person in the courtroom. We are the most important because we are our client's advocate, and we have the chance to persuade people that our client deserves to win. And if we don't do a good job, they're not going to win, because the odds are against us for a lot of different reasons and in a lot of different ways. So we have to do a good job, but we're the least important because jurors don't care that much about us as people, with some few exceptions. You know, we think we step into the courtroom and we think we're the center of the movie. We're the star, we're the protagonist. But each of those jurors thinks they're the protagonist. Of course, the judge is convinced he or she is the protagonist. The jurors don't care if you own a golden retriever, where you went to college, you know, even really how you're dressed. Even though they make comments about how you're dressed, that's just something they look upon because they're bored. All they really care about is, are you a reliable source of information? And all the energy we spend trying to project a certain image or trying to protect against them seeing a certain part of ourselves is wasted energy. It drags us down. It saps our strength. But I would say, you know, 90% of lawyers spend a significant amount of energy protecting their self-image. Which brings me to the third, you know, how do you get out of that? How do you stop doing that? I'm sure there are lots of ways. I'm going to tell you my way, which is, and it took me, I'm embarrassed to say, decades to get to this place. Yeah, I mean, part of the reason I share these ideas with other people is in the hope that maybe someone won't have to suffer quite as much as I did in my career. So, so how do you get past this fear that your self-image is somehow going to be hurt in a trial? And I would suggest having a state of mind, something like this, that you say to yourself, and I think this is all true, I am here at this trial for reasons bigger than myself. There are lawyers who would do a better job on this case than I would. There are lawyers who would do a worse job. But I'm the one at this time, in this place, charged with advocating for this client. If I fail, it will not be from lack of effort. It will not be from lack of integrity. It will not be from lack of caring. I may fail because I lack enough skill or talent. I will try to learn from the experience and do better next time. I may fail because of forces outside of my control. I will not let that cause me to become cynical or discouraged. I will always remember it is an honor and a privilege to have the job I have, to be able to fight on a daily basis for things I believe in. To me, that's how you get over yourself. You recognize that things way bigger than you are going on in the courtroom. You're a bit player. I mean, again, you're the most important, you're the least important, but you're not God. You can't control the courtroom. You can't control what happens there. All you can do is show up, do your best, put everything you have into it, and let the chips fall where they have. And if the case is about you and your self-image, in your concerns and your little self, then you're always going to have fear. But if the case is about something bigger than you, you can't lose. All of these trials, most of these trials we do, are fights between human values and corporate values. As long as you keep fighting for human values, you can't lose. You may lose a battle, you may lose a bunch of battles, but you can't lose. But if the case is about your little self, you can lose all the time, and you're going to have fear all the time. So let me go to the last type of fear, which is what I think of as historical fear. Let's take the example of a 5-year-old who tries to cook on a stove at age 5 and gets badly burned. So for years afterwards, she's afraid of stoves. Makes sense? But gradually over time, she sees her parents using the stove. As she gets to the right age, they start to teach her how to use a stove. She's always going to be careful around stoves, but she develops the skill to use the stove safely, and her fears subside. That's a healthy fear, right? Fear plays an important protective role in our survival, but it can also outlive its usefulness. We all get burned by our families of origin. A 5-year-old is shamed, ridiculed, bullied by his father. And father is an all-powerful figure who literally has the power of life and death over his child. So the child develops various ways of dealing with a shaming, bullying father. And 30 years later, the child is more powerful than the father by any objective measure, right? The child is bigger, stronger, maybe wealthier. But unlike the child who was taught how to use the stove by loving, responsible adults, the child who was burned by his father or his mother, for now we're talking shame, ridicule, bullying, was never taught how to deal with a shaming, ridiculing, bullying authority figure. So that fear of authority figures never goes away. And that person may decide to become a lawyer and fight for the underdog to protect people against being bullied and shamed and so on. But that fear is still there because it's never really been dealt with. And how will that person react when the judge rules against him unfairly or fairly? You know, the potential to be triggered into an overreaction is enormous. And all of us have these childhood messages. And I'm going to suggest to you that the messages we get as children are often the real sources of our fears in the courtroom. And the messages we get are things like this: I'm not lovable unless I'm successful. I'm not lovable unless I'm successful. So I can't tolerate the thought of losing. I'm not lovable unless I'm perfect. So I'm afraid of making a mistake. I'm a perfectionist. I learned that people with power and authority will hurt me. So I'm at least unconsciously afraid of being in their presence. I watched how interpersonal conflict leads to very bad things happening to me. So I'm afraid of conflict. When I'm really seen, I am rejected. So I'm afraid of being myself in the courtroom. We all have our personal recipe of childhood messages that are baked deeply into our personalities, so deeply that we're often unaware of them or only dimly aware of them. It's surprising, isn't it, how many trial lawyers are afraid of interpersonal conflict? What a clue to our own psyches. So we bring these historical messages and fears with us into the courtroom. And in the courtroom, we think the fear that we're feeling is a result of the things that are happening in the present. But most of what we're really feeling is hurt and fear from the past. It's never been dealt with completely. So for example, the first time I had a speaking part in a trial was a little misdemeanor case. I was the prosecutor. I stood up to do voir dire. Everybody was looking at me and I couldn't get a word out of my mouth. I literally could not speak. I opened my mouth. I tried to force air out. I could not speak. I went back to the table, got a glass of water, took a sip, went back in front of the jury, tried to talk. Nothing would come out. Went back to the table, flipped through some pages, back to the jury. Nothing would come out. And the trial judge said, well, if you're not going to ask any questions, I will. And now, why would I be so afraid in this courtroom? And the truth is, at that age, my early 20s, I still had a big ball of, you are an awkward, ugly, stupid, my childhood messages, all that going on in me. And so I was afraid unconsciously, it was not conscious. They're going to see who I am. They're going to see the ugly parts of me, the awkward parts of me, the lazy, the stupid, the shameful parts of me. Well, no wonder I couldn't talk. Now that's kind of an extreme event and an extreme reaction, but I'm going to suggest to you that probably every single one of you has similar things going on when you go into trial. And over time, as we get more experienced, we get pretty good at covering that all up, as I did. And I covered it up for some 20 years until, a personal crisis caused everything to collapse, and then I had to like put myself back together. But what we're doing is we're reacting not just to the events in the present, but to the wounds and fears that have been festering for decades. We overreact, getting more angry than the situation calls for. We lose our objectivity, seeing things through the lens of childhood. We panic, we freeze. These are the things that interfere with us being the kind of messenger we could be. And the bottom line is we need to learn to feel safe in the courtroom. And there are two ways to do that, and they are not mutually exclusive, but most of us only use the first way. And the first way is you just spend a lot of time in the courtroom, and you get more and more comfortable, and you get less and less worried about performance anxiety. And you get better and better at sort of covering up and papering over your unconscious fears. But the fact is, it continues to take energy to do that. It's distracting, both mentally distracting and physically distracting. And so trials are harder for us than they need to be. The other way to feel safe in the courtroom is to go into the dark alley, to look at the parts of ourselves we don't want anyone to see and bring them back into the light, get comfortable with them, and they lose their hold on us. As they come into the light, they lose their power. Now, lawyers new to the courtroom are always going to have, it's natural to have a certain amount of performance stress or performance anxiety. That's just normal whenever you try something new, that you're going to have a certain amount of anxiety. And that's not what I'm talking about. I think that's clear. I'm talking about debilitating fear, things that really interfere with your performance in one way or another. So, I've heard lawyer perfectionists say, I'm a perfectionist, which can help me in my job sometimes, but in the courtroom, I am so much of a perfectionist that if I make the slightest slip up, then that's all I can think of. So I can't just move on. It's like, oh, I can't believe I mispronounced that word. And I keep coming back to that when I want to be focused on what's now happening. Well, that's the way a perfectionist can be crippled. Or, anger is really common one for trial lawyers. I get angry. The judge is stupid. He did a stupid, unfair thing, but I blew up, and now that's hurt my case. I heard of one lawyer, this is not anyone I know personally, who, ultimately went to counseling because he had blown up at opposing counsel so badly in the courtroom that the judge sanctioned him. And he said, I know I'm smarter than that. I know not to do that. I don't know why I did that. I lose control of myself in the courtroom, and I don't know why. These are obviously self-defeating behaviors. So I'm going to give you a couple questions to ask yourselves, a few questions to ask yourselves as you think about this for yourself. What exactly am I afraid of when I think about going into trial? Where's the fear coming from? Am I really experiencing fear about what will happen to my client? Or am I using that to distract myself from more uncomfortable thoughts and fears? Is my ego really so fragile that it's terrified of losing a trial? When is the first time I felt fear like this? The second time? Those are really good questions. So, if you feel anger at an unfair ruling, when's the first time I felt anger like this? And most people will go back kind of chronologically. Well, I remember in college where my professor said this. And I remember in high school where my girlfriend did that. But if you keep going back further and further, and sometimes you need the help, most times you need the help of a therapist or whatever. But if you're doing this on your own, if you go back to the earliest time you felt like that, you're probably getting clues as to what's really going on in the courtroom. And if you pay attention to those fears, those overreactions, those underreactions, because just like you can overreact, you can underreact and just not be, I don't know. I did a trial once, probably 20 years or more ago, long trial, 5 or 6 weeks. We won the trial. When it was all over, we learned the jurors had nicknames for all of us. And one of the jurors told me that my nickname was Flatline. He said, because we couldn't tell if you even cared about the case till closing argument. It just seemed like you were a robot. You know, so you can underreact in the courtroom too. But if you start to pay attention to what's really, first to the feelings and then where their source might be, you can start to get a handle on, well, I can guarantee the fear will start to subside. The maladaptive behaviors and reactions will start to subside. And you might be curious enough at that point to want to do more and try to dig deeper. But if the fear's gone, and this is the last thing the last kind of topic I want to address, those of us who've lived with fear so long, decades in the courtroom feeling fear, there's yet another fear, like, who will I be without my fear? What's going to be left? What's going to energize me? What's going to drive me? What's going to be my compass? If I'm not there to protect my little ego, what am I there to do? If I'm not there to, rip my heart open and cry about my client, what's left? What will be left if I take away my own fear? I think some questions can be helpful in that regard. You can ask yourself, why am I standing in this courtroom at this time with this client? You know, for a lot of us, I want to make some money, of course, that's part of the answer. For most of us, that's not the whole answer. For those of us that it's the whole answer, ethos may not be the way to go for you. But if there's something else going on inside you besides the money, then ask yourself, why am I standing in this courtroom at this time with this client? How does this moment serve my values and my destiny? How does it nourish my heart? If you can honestly answer those questions for yourself in a way that satisfies yourself, you will have a power most lawyers don't have. Most lawyers don't have that. You might even want to write yourself a personal mission statement. This is mine. I believe every person is entitled to respect and dignity, that the strong should not get away with preying upon the weak, that there is meaning to our existence beyond the material, that corporate efforts to flatten the human experience must be resisted at every turn, that governmental efforts to deny the humanity of those accused of crime must be resisted at every turn. If that's what you're about when you walk into the courtroom, again, not in a self-righteous way, this is all about internal stuff. I think that can take the place of fear. So now, having done that, I would like to see if we can't get some questions or dialogue going. Or if not, you're all going to get out of here early. I see a question already, so give me a second to kind of get this up.
You got it okay, Rick?
Oh, not a question. Well, that doesn't help, Joe. Come on. Not a question, but I think you should know I am standing up in my living room applauding. I can't help but imagine what my career might have been had someone given me this last 90 minutes 20 years ago. Yeah, Joe, I feel your pain. When I wrote my third book on becoming a trial lawyer, I thought it was going to be just a sort of essays and practical tips on things I'd learned as a trial lawyer. Thought it'd be my last book. I got about halfway through it and realized, oh, I'm writing this book for people so that they don't have to go through the pain I went through. And then I got about 3/4 of the way through it and I realized, oh, yeah, I said I'm doing this for other people, but I'm really trying to heal myself here over too much time spent in fear, in pain, in discomfort. So yeah, totally get it, Joe. All right, so anybody who has a topic they want to talk about, I'm happy to talk about anything, and I'm also happy to get on my way. So yeah, I don't know, Greg, what did I say about Jerry Spence? Greg, do you mind getting on the voice thing? And I'm not sure what you're thanking me for in terms of Jerry Spence. And it might be a good takeoff point for a discussion.
Yeah, let me see if I can get Greg on here. Let's find Greg. Where is he? It's hard because I have to scroll through everybody. So here's Greg. Greg, I'm going to allow you to talk just to ask. And let me unmute. Okay, let's see if this works. Greg, you have the floor. Greg Smith.
Well, I don't want to hold everyone up, but no, I mean, this was all about, this is the thrust of Jerry Spence's whole notion is finding yourself,
Absolutely.
Jury of 12 people with 600 years of experience, and they can see right through you. And unless you get genuine and real with who you are and comfortable in that somehow, which is the challenge, you're never really going to be, if you're putting up walls that we always put up and the jury sees that, they're going to trust you less. And this is what his whole concept is about, and how hard it is. I mean, you got to work on yourself, which is way harder than working on trial techniques.
Absolutely. Yeah. Thanks, Greg. And Spence was a revolutionary genius. When I first started practicing, and I don't know how old you are, but when I first started practicing, what we were told was, go in and control the courtroom. And it was sort of fashionable to be cynical. I could do any side of a case. I'm just a gunslinger, a macho, tough guy. And, it's kind of weak sauce to even care about the client, and one of the many things Spence did was to say, no, caring about the client is a very important force. And what I was trying to communicate today is that I think for some people, so at one point the profession was kind of in this cynical place where, the client's superfluous and it's all about what a tough, cool guy I am, because they were mostly guys at the time, but there were women trial lawyers who had that same attitude. And then Spence kind of opened everybody's eyes to, no, caring about the client is a powerful force. In my opinion, that pendulum for some people has swung too far. And that's the vicarious fear I was talking about, where it's kind of become a badge of honor to wring your hands and, say that you're so afraid of what's going on for the client. And I think many times it's a way of hiding from ourselves, which is, but anyway, yeah, Spence is the guy. He's not perfect, but he has revolutionized our world, no question. Ken says, I have found that each day of trial, I experience the various gastroenterol, I'm not going to pronounce that word right. I know what you mean. Stomach and intestinal problems that I associate with trial. But over the years, I've learned that when I feel this way, I perform at a higher level. Do you intend that your suggested techniques will eliminate this as well? I feel that these feelings are my friend. Yeah, I mean, I totally get what you're saying, Ken. But yes, I am saying that I believe you can go to trial without having an upset stomach and perform even better than you have in the past. But the only way to do that is to get at the I was going to say at the guts of, yeah, to get at the guts of what you're what's riling you up so much in the first place. And yes, I do believe there is a way that you can go to even a higher level. Now, you may not want to do that. You know, maybe you're thinking, I'm doing perfectly fine, thanks. I've gotten used to having an upset stomach and I'm winning most of my trials, all the ones I should win, and my life is great. So I don't need to do anything more, which is fine. I mean, I am not criticizing that, but I am suggesting that if you wanted to, what would it be? I was just talking to my wife the other day because I'm getting ready for a trial, and I was saying, you know, 10 years ago, I'd be not sleeping very well and really stressed out, and how nice it is in the last few years, I can go to trial without sleepless nights and without upset stomach and you know what? I still win. Yeah. So, you know, I'm not trying to change anybody. Everybody should do what they want to do. I am just suggesting that that is not the price of admission. I paid a terrible price for winning cases, and I've learned that I don't have to pay that price to win cases. And I see, let's just go to Alan Siegel. He said he raised his hand to ask a question. Can you find him, Mary?
Yes, I can. And now, Alan, if you just unmute yourself, you should be able to talk.
I think I'm unmuted. Can everybody hear me?
Yep.
Great. Well, first I wanted to thank you for joining us, Rick. You know, I love your work. I love Rules of the Road. And my question really goes to polarizing the case. And maybe since we have a little extra time,
you bet,
it'll open that up a little bit and maybe give you something else to talk about. But combining the discussion today with polarizing the case, I will still say that one of my biggest fears when I go to trial is that my client is going to be attacked, and that my client's credibility is going to be attacked, and that he or she is going to feel very badly about the whole process. I often will coach my clients in the beginning not to feel bad about themselves and not to let what's going to happen over the next week or two, you know, personally get to them, because the lawyer is going to attack them and call them names and allege that they are doing all kinds of terrible things that they would never imagine in their life that they would do. Yet they're going to be sitting here and these jurors are going to be looking at them, maybe thinking the worst about them. And that is one of my biggest fears. So I thought maybe you could combine the topic today about maybe either protecting your client from that or using that as you discuss and polarizing the case to your benefit.
Well, I want to ask you first, Alan. I will answer your question, but let me ask you this. Why are you afraid of that? Like, what, you're afraid they're going to attack your client, but, you know, that's like me saying I'm afraid a lion's going to come in through the conference room. Okay, but what I'm really afraid of is that the lion's going to eat me. And not that you know, if someone said a lion's going to come through the conference room and not eat me, it's just going to sit there and lie down on the floor, I don't think I'd have a whole lot of fear. But so I guess I'm asking, why are you afraid? You say one of my biggest fears is that they're going to attack my client. Well, that's kind of a given in most of our cases. So what are you really afraid of below, you know, they're going to attack your client, so what?
Well, I mean, two components. One, the one I just discussed, is that, you know, I worry that it's going to have an impact on the client, and I feel bad about that. And number two, of course, I fear that it will have a negative impact on the case and will inhibit our ability to get a good verdict on behalf of the client. So between those two things, that's what worries me. I agree that it is inevitable, and it, you know, I say I worry about it like it's I realize it's going to happen, but I fear that it's going to have a negative impact on my client as you know, my client's psyche, and I fear that it's going to potentially have a negative impact on the case.
Yeah, I'm not, and I don't want to quibble with you, but I'm not sure fear is the right word. I mean, you are worried, you know, or, you know, you're anticipating, let's say that, you're anticipating that they're going to attack your client, and you want to do your best to keep your client from being hurt, and you want to do your best to win the case. Is that a fair statement?
That's a fair statement.
Yeah, okay. So, I mean, all you can do is let, you know, sometimes I'll actually give my clients the polarizing book and say, you know, this is so basic to what they do that I wrote a book about it. And here's the book, and go ahead and read it. And for the smart clients and the educated clients, it has seemed to help sometimes. But I say you don't have to memorize the book. It's just to really convey to you that this is what happens in the courtroom. They're going to try to make you look like a liar, and I'm going to try to make sure the jury sees the truth. And that's the game. That's, you know, if they had the truth on their side, they wouldn't have to try to make you look like a liar. But this is the only thing open to them. And that's what I'm going to try to tell the jury too. And then, you know, obviously, I mean, it sounds like you've read the polarizing book. I mean, that was the whole purpose of that book was, you know, to not be afraid of it. I actually welcome it now when they attack the client, because I really do think, you know, and as defense lawyers have gotten more sophisticated, they've stopped attacking the clients as often and as openly, and try to find sneakier and sneakier ways to do it, because it's sort of like the unconscious fears we were talking about earlier. If you bring them out into the light, they lose their power. You know, we've seen this with IME doctors all the time. If an IME doctor says, you know, jury, things just aren't matching up here. She said she was on her way to the grocery store when she talked to the police, but the hospital record says she was on the way to pick up her kids. There's a you know, inconsistency here that's really troubling. And they just go through these inconsistencies and talk about how troubling they are. That's harder to deal with than if they just come out and say, I think this client's a liar and a fraud trying to get secondary gain. I love it when they come out and say, client's a liar and a fraud and seeking secondary gain, because then that's the start of the trial. Members of the jury, if you think my client's a fraud, throw him out of court with nothing. There's no reason you should give them anything. But on the other hand, the defendant's doing that just to gain advantage in this lawsuit. They have no honor, they have no shame. And, you know, my client deserves every penny she should get. So I don't know if I'm really answering your question. I'm trying to. Am I getting at the thing that you're?
Well, yes. I mean, you know, it wasn't necessarily a direct question, if you will. I was just kind of opening it up to you because you had said maybe, you know,
sure,
you know, we could go in different directions. So I was just kind of bringing up a topic that I thought everyone would appreciate, and that you have a particular specialty. And so I wasn't looking for a particular answer.
Okay,
so
cool.
I think you've addressed
yeah,
it
yeah.
sufficiently.
I mean,
you want to talk about it more, of course, you know, we can
okay.
talk polarizing.
Okay, well, you make a good point. I mean, in a way, the polarizing book is about this very thing we talked about. I mean, the first time I stood up and said to a jury an opening statement, your main job in this case is to decide whether my client is a liar, a cheat, and a fraud. It was scary as hell because what if they did, right? I mean, what if they decided? But that is the truth of the matter. And that's something that I do spend, I mean, a lot of time in the polarizing book. That's the whole polarizing book, so to speak. But then also a lot of time in this more recent book talking about one way to address your own fears is to allow yourself to see clearly the issues that are in dispute. The defense often, very often, does not want those issues to be clear. But to make the issues clear for the jury, we have to first be willing to clearly look at them ourselves. Like, oh, my client did, at least the records reflect an inconsistent statement on the part of my client. You know, she said she was going on the way to the grocery store versus on her way to pick up her kids at school. You know, there are warts in our cases, or things that the defense will seize on and say are warts. And we have to look at them, you know, very objectively and clearly. And yeah, so that's a big, whatever the case, whatever the problem, our greatest strength is to be truth speakers. But you can't speak the truth if you're paralyzed by your own fear, your own denial, your own avoidance, things like that. So yeah, I'm happy to talk more about that if somebody wants me to, but I think it really does relate, like Alan was saying, to what we've talked about earlier. So Bill asked, do you not differentiate between managing yourself, i.e. fear, and managing stress, which gives you an opportunity and motivation to excel? Yeah, I do think there's a difference. So I feel a lot of stress right now because I'm going to go to trial, and a really big trial, and there's a lot of work to be done. And I'm feeling that pressure of, you know, I got a lot of stuff to read. I got a lot of things to think about. I've got a lot of cross-examinations to put together. I'm feeling that pressure, no question. And that pressure does keep me moving. It means that tomorrow morning I'm going to get up and I'm going to sit at the computer and work on a cross-examination, not going to go for a walk or something I might prefer to do. So I think in that sense, that's how I'm thinking of stress. The stress of having to perform, of having to get work done, of making something better. So, you know, there's the stress of, okay, I wrote this brief. It's not as good as I want. I've got standards. I've got pride. I want to make sure this brief is the best I can make it. So I'm going to spend tomorrow afternoon going back to it, even though I maybe don't have to try to make it even better. But what I'm not, I mean, I'm litigating right now. I'm just using this as an example because it's coming to mind, but in this trial that's going to start in about 2 months, we got to the eve of trial. We even got a jury selected last November. Then because of COVID, it got canceled. But over the course of the last 6 months, I've briefed this one issue. 20 briefs have been filed by the parties on this one issue, 8 to 10 hours of oral argument. The judge granted or ruled our way. Then the defense moved for reconsideration. Then the judge asked for briefing and then ruled our way again. And then the judge sua sponte brought it up and said, I want to reconsider again. And this is a huge issue in the case. And, you know, I don't see how we lose this case if we win this issue. So it's a huge issue in this case. But I mean, in the old days, responding to Bill's question, I not only would feel the pressure and stress of getting the judge to get this right, but I'd also have this fear, like an outsized fear, that the world is going to end if I lose. And that's what I'm trying to help people with as best I can, to shine a light on that kind of fear. And so, yeah, I do draw a distinction between those two. I was not aware, responding to Ron's question, I was not aware that Bill Russell threw up before every game and has more rings than any other ball player. Did not know either of those facts. You know, and that's great. And, you know, I also think there's, I'm not an expert by any means on any of this stuff, but my impression is that athletics are different to some extent because you are trying to rev up your body. You know, Bill Russell's not out on the court trying to make an intricate legal argument or thread a delicate cross-examination needle. He's performing physically. And so, you know, maybe it's good he threw up every morning. I really don't know the answer to that, but I do not believe going into court kind of worn down by fear is good for the trial lawyer. Yeah. All right, Libby asks, can you talk about your decision to open a solo practice after graduating from Harvard Law School? Was that a blow to your ego? How do you know it was the right decision? Well, I don't know it was the right decision. I didn't have much of a decision to make. You know, I probably had the lowest grade point average in my law school class. The plan was 3 friends and I were going to open a law practice in Boston after we graduated. But one by one, each of them took a job at a big firm. And I interviewed at some big firms, but did not get any job offers. And I had spent the summer before in Alaska in the DA's office. And honestly, I wasn't even sure I wanted to be a lawyer. I mean, I was 22 when I graduated from law school, and I wasn't sure. I went to law school because I didn't know what else to do, didn't know what I was going to do with my life. And so, you know, I honestly thought I was going to become a novelist. And so, or that's what I wanted to be anyway. So law was something to do until I got to my real goal. And obviously things didn't work out that way. But yeah, I hope that answers your question. And yeah, I'm happy to take other questions. All right. George says, I have a problem preparing and striking the balance on an opening statement. No problem with closing, but figuring out the right tone for opening has been a problem. My question is, how do you prepare your opening and what tone do you try to convey? I think in terms of tone, the biggest mistake lawyers make is assuming that their own feelings about the case can be communicated in opening. And what I mean by that is, you know, if the defendant has done something really awful and outrageous, I don't know, I used to do a lot of insurance disability cases where the insurance company would intentionally deny insurance claims for people who were clearly entitled to. And, you know, their internal memos showing that this company made a conscious decision to deny valid claims because they needed the money. So, you know, that's pretty outrageous. You take money from people for 20 years, promising them you'll step in and take care of them when they're disabled. Then when they are disabled and they need the money, you intentionally screw them over, sort of gin up false reasons to deny their claims. It's all laid out in the corporate documents. It'd be really easy to come into court and say, you know, this is a case of a company that put profits over people. This is a scumbag company. Let me tell you how bad they are. Well, I don't think that's very effective. And the tone I try to get is that of a teacher, and try to be pretty matter of fact. If the facts are outrageous, the jury will come to that conclusion. If I tell them they should be outraged, they're going to resist. They don't want people telling them how they should feel. And I don't mean just explicitly telling them how to feel, but implicitly telling them how to feel. They want to come to their own conclusions, and they want to think that they're being fact-driven conclusions. So one way that I've sort of come to recently, you know, last 4 or 5 years that I sometimes start with is, at the end of this trial, your job is going to be to decide, and then I take what I think is the central contested issue. So I may say one of your jobs, or I may say your job, depending, maybe there's only one issue, but I may say at the end of this trial, one of your jobs is going to be to decide whether Monsanto's PCB chemicals were defective. There's a couple of great things about starting that way. Number one, an audience always loves it if you talk about them. You know you will hold their attention as long as you're talking about them. So if you start off with one of your jobs will be, you're talking about them and they like that. And then you frame the issue. Your job will be, are these chemicals defective? Now you've framed the issue, and then you can move into, and here's what you're going to hear about that, or here's the legal definition of defective, and then here's what you're going to hear about this. So I try to be pretty logical, pretty, tell an interesting story, but also not get super emotional, not try to tell them directly or indirectly how they should feel, but more let the facts, I guess I would say, let the facts speak for themselves. And the other thing, as long as we're talking about opening, is I would say my openings have gotten shorter and shorter and shorter as I've gotten more and more experienced. The reason for that is I've come to really appreciate what I think of as the fire hose effect. So we learn all these facts. And this is more true for complex cases. I mean, if you've got a traffic accident case, I think this is less of a danger, but I think the lesson is still true. If you've got a complex case, you've worked on it for a couple years, you could talk about this case for 10 hours nonstop, going through every single fact. A lot of lawyers, including me, used to be try to hit every important fact in opening. The problem with doing that is the jurors can only absorb so much in the first hour, let's say. And to hit them, try to cram more and more stuff into that hour just dilutes everything. So, and that's why I call it the fire hose effect. You're dying of thirst. Would you rather somebody handed you a glass of water, or turned a fire hose on you and let you try to drink that way? It's really hard to get the water in from a fire hose. And I think that's what a lot of opening statements end up looking like, is a fire hose of facts. I think one of the wisest thing ever said about trials was by a really prominent plaintiff lawyer here in Washington, Paul Rivera. He said, trials are a battle of impressions. So I want the impression at the end of my opening to be that we are morally right, that we have the better facts, and we have the better clients. But how you structure it, of course, is going to always depend on what the case is. But I will say this: I think way more plaintiff lawyers make the mistake of having too emotional a tone than having too little of an emotional tone. Way better to just be the professor, the teacher. Here's what the facts are of this case. Here's what it'll show. I hope that answered your question. If you got more follow-up or whatever, I'm happy to follow up. Just see what comes next. All right, it's a Friday afternoon where you guys are. Oh, here we go. We have 15, 20 more minutes, so I'm happy to take questions, but I'm also happy to let you guys go. But here we got a question. How do you write your books? How do you find the time? What is your process or methodology? The first book, Rules of the Road, I started using the Rules of the Road approach in cases and got some good verdicts, and people started asking me to lecture on the subject. So I would lecture and I would lecture and I would lecture, and I got really tired of lecturing about Rules of the Road. And, there's a little more to the story than that, but ultimately I thought I'll just write a book. And then I won't have to lecture about Rules of the Road anymore. And really, I had lectured so much about it and I'd used it in trial, of course, so much that I could write the first draft. Took me about 3 weeks. And I was just on vacation in Mexico, and every morning I just get up and it would kind of spill out of me because it kind of had written in my head. And then, after that first draft, I got a hold of Pat Malone and we brainstormed and we fine-tuned it, and he had, really important contributions. But from my part of it, it came pretty naturally from having lectured. and I thought at the time I wrote it, that's my only book. And, but I kind of enjoyed the process. And then that's when I started what became my third book, which was going to just be a group of essays, I thought. But then I kept getting questions at CLEs about malingering over and over and over as I'd speak at CLEs. You know, they're calling my client a liar, a cheat, and a fraud. What do you do about that? And I did have this approach I was using, I called polarizing. I thought, all right, I'm going to interrupt my becoming a trial lawyer. I'm going to write a 50-page pamphlet on how to polarize a case. And it just kind of evolved. It got longer than I had expected. And so that, you know, I don't plan it out, I guess I would say. Most of this, you know, I'm not here today to sell books. The royalties are laughably small. Of course, I want people to read my books because it's gratifying and satisfying to hear that they've helped people. But a big part of why I do CLEs is that they force me to think. You know, I get questions about things, I get pushed, I get stimulated. And, you know, really the CLE process, me being a CLE speaker, takes me places I don't always expect to go. And that's the part that, that's why I do the CLEs. And that has resulted, frankly, in my books. I mean, my guess is if I'd never done a CLE, I'd never have written a book. But they have kind of forced me to do that, and I've enjoyed every one of them. Okay, so here's a question from someone who doesn't want me to share their name because it's personal. My experience is that bringing light to my fear is not enough to dissipate the fear. The second component to removing fear is I have to learn to surrender myself to my higher power, God, as I understand God to be. I choose to do God's will rather than my own, and I trust God knows what's best. That takes away my fear, and it has changed my entire demeanor in the courtroom, my interactions with opposing counsel and my clients, and my entire outlook on what my work means. I am more present, serene, and fearless than ever. The surrender happened for me fairly recently, and there's a lot more to it. God, and then he says, what I'm sharing here, but since you did not mention God, higher power in your discussion of fear, I thought it's something worth bringing up. Oh yeah, bingo, 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 bingo. You know, the little mission statement I read to you was trying to evoke that. You know, we all have, well, let me put it this way. If you can find something bigger than yourself to take with you into the courtroom, your fear will dissipate. And everybody has their own conception of God. Everybody has their own conception of the world and, you know, higher powers and spirit and soul. And, you know, I am not going to try to comment on any of that, not because I'm afraid of it. I'm fascinated by it. But I think the point that this person is pointing to is 100% true. It's back to what I was saying. If it's just you, your little self, small s, of course you're going to be afraid. That is the essence of having an ego, is fear. And if you can make the trial about something bigger than you, more important than you, the fear goes away. And it's kind of magical. So, yeah. Thank you for that comment. And I see another question. This is the question. What do you think is lost or gained through video communications, both generally for the human experience and for trials, and for those who have to conduct trials remotely? More specifically, can this medium help eliminate some of the fear that we experience in a courtroom setting? And if so, can it help us be more comfortable with ourselves and therefore more real in some way? Well, that's an interesting question. I mean, we could spend 3 hours talking just about that, but briefly, I've been doing video depositions for, well, on a regular basis for 15 years. I don't think much is lost by doing a video deposition. I know other people disagree with me, but especially as the technology has gotten better and better, I think more is gained than is lost. As for trials, I've not done a video trial. Is it possible to put the question back up, Mary? Just thank you for doing that, but I was just hoping to keep, or here, I got it, I found it back. I want to make sure I answer all the aspects. Video depositions, I think virtually nothing is lost. It can be a little more complicated, but nothing is lost. I haven't done a trial, but I did a video jury selection, and my brother did a video trial, kicking and screaming, and when it was done, he became a fan. My experience in video voir dire was that the jurors seemed way more comfortable and relaxed, and the result was I think we got more honest answers from the jurors. They're all in their houses or their offices. And I think, yeah, I think we got more sincere, direct, honest answers from the jurors. And my brother, who did the trial, said he felt like the crosses went well, the directs went well. I don't know what that's going to do. Like if we all start doing video, I would be very sad if we lost in-person trials for good. I don't think we're going to. But I expect we're going to see more and more video. I've done a lot of video oral arguments in the last year, and I don't think much is lost there. A few times I felt like I wished I'd been there in person, but mostly you add up the time savings and the travel costs and all that. But then as to, I don't know if it's going to change the fear part. That's a really interesting question. I'm sorry, I just don't have a good answer. I guess time will tell if that's where we go. I think that's the best I can do. And we'll give 2 more minutes for anyone to ask a question, and or raise a hand or whatever they want to do. And if not, I just want to thank you all for letting me think about these issues, because it's one of my favorite things to do, and I hope you all found it worthwhile. Sorry to catch you in mid-chew, Mary.
My almonds. Well, I received so many really heartful comments to my email as this was going on, Rick. You really, I think, spoke to people, touched a nerve, I think, or touched their hearts. And it was really interesting to see. I think this whole discussion around fear was, and some self-reflection was really, really resonated. So I thank you for spending these hours with us. I know you're a busy person, so I truly appreciate it. And with that, I'm going to let you go because I know you're busy.
All right. Cool. Thank you, guys. I'll talk to you later.
Thank you, everyone, for joining. Bye-bye, all.